Deputy Bank.
Yes. Ms. Henry. It's all right, we have it written here. Thank you. Yes, indeed.
Lady, this appeal concerns the decision of the Court of Appeal of Antigua and Barbuda to imply a term into the purchase and assumption agreement between the appellant and the Eastern Caribbean Central Bank. And I believe that the court is familiar with the chronology of events that led up to the circumstances giving rise to this case. And I believe that it would be helpful, perhaps, if a matter which may have impacted on the decision of the Court of Appeal is highlighted at this point. Because the court is well aware that the respondent was removed from office in February 2009, and that on the 12th of October 2010, a purchase and assumption agreement was executed between the respondent's former employers, let me put it this way, the central bank, which had taken over the operation of the respondent's former employers, and the appellant. And that agreement was put into effect 6 days later, on the 18th of October 2010. But the terms of that agreement did not become known to anyone because there was a confidentiality agreement within that larger agreement. They did not become known to anyone until an order of court was made in November of 2011. And the significance of that, perhaps, milady, is that when the case was pleaded before the industrial court originally, the contention of the respondent was that all of the assets of the former Bank of Antigua and all of the liabilities were sold on to the appellant. And in point of fact, the term was used that whereas a judgment was entered less than a month later against the Bank of Antigua, in the pleadings and in the submissions before the Court of Appeal and in the submissions before this court, the position that had been taken by the respondent is that he was left holding an empty bag and that there was nothing in Bank of Antigua for him to use to enforce his judgment. So I refer to paragraph 8 of my submissions, in which I refer to the appellant's memorandum, which is at pages 81 to 84 of Part 1, Tab B of the Record of Appeal. And I hope that the court will forgive me for being not very deft with the electronic version of
So it's page 81 to 84, is it?
My apologies, my lady. Pages 81 to 84, Part 1,
Yes.
Tab B. That is where the appellant's memorandum is. Sorry, not the appellant.
No, not the appellant.
No,
Should we say employee?
the employee.
Should we say employee and bank?
That's correct.
That would be the easiest way of doing it, because otherwise we get very confused about who was the appellant in the Court of Appeal,
Who
and
is
who
that?
is the appellant here, and so on and so
Thank you
forth.
very much, milady.
So anyway, the employees' memorandum.
That's correct.
No, it isn't. No, this is this is the bank's memorandum. Sorry.
Paragraph 15 of the employees' memorandum.
No, it's the bank's memorandum that what we've got. Sorry, I was.
No, the employees' memorandum.
Well, that starts at 73, I think, Ms. Henry. Which paragraph did you want?
Paragraph 15.
Well, isn't that on 76?
Wait, just have my
It is, yes.
Yes,
Yes.
my apologies.
Yes, and that conforms with what you say. And
My apologies.
Yes, no, that's good.
Okay, so that in the last sentence of that paragraph, by the agreement between the two entities, the employee contends that ECAB had assumed all of the profitable trade assets and assets of Bank of Antigua, while Bank of Antigua remains a shell with no assets, a mere banking license, and irrecoverable loans. But that, my lady, is inconsistent with the witness statement, the evidence, which has remained uncontroverted. Paragraph 5 of the witness statement of William McDavid, which is at page 94 of the record. ECAB did not buy the business of Bank of Antigua. Bank of Antigua is a separate entity from ECAB and continues as an entity distinct from ECAB with assets and liabilities which are separate from those of ECAB. And also evidence under cross-examination of the same witness, Matt David, because there is no reference to this in the other witnesses' evidence. But if the court will look with me at the evidence of William McDavid, which starts at page 64 of the record, and I'm referring now to paragraph 45, which is on page 68. Well, it actually starts in 67, paragraph 44. Prior to ECAB's taking over Bank of Antigua in October 2010, Bank of Antigua was aware of Mr. Byron's claim for compensation. If Mr. Byron was successful, then this would have been a liability of Bank of Antigua. Under the purchase and assumption agreement, ECAB took over certain liabilities of Bank of Antigua. The liabilities assumed by ECAB were deposit liabilities. Mr. Byron's liability was never settled and he was never paid. Bank of Antigua continued to exist and has substantial assets. There are various assets, physical assets, which are still owned by Bank of Antigua. For example, there's a property which is located on High Street in St. John's in Antigua and Barbuda that is owned by Bank of Antigua.
Well, we read all that and we said to ourselves, perhaps, well, it may have had assets, but I wonder how many creditors it had. But in a sense, Ms. Henry, is this really relevant to the main issue about implication here? Whether if he's left with a right against the Bank of Antigua, he's going to be able to enforce his judgment, may not be central to the issue that we have to decide.
Well, we see that it is central in that one of the considerations that the court must take into account was the state of knowledge of the parties at the time of the execution of the agreement. And that is one of the reasons why I pointed to the chronology, where in 2010, October, there was no judgment in favor of Mr. Byron. There was no liability declared by a court.
Well, was there no liability, or only no liability declared
by a court?
These are different things, are they?
I understand that.
If there's a statutory right, then even if a court hasn't actually found in favour, it's still a debt, isn't it?
I understand that, my lady. That would have been something which was known to the bank, as Mr. McDavid has said, to Bank of Antigua. And the parties contracted on that footing, and they did not include Mr. Byron's liability as part of the contract. Plainly so, because he was later on the subject of the implication. And so our contention in that regard is that the plain language of the contract does not give rise to an absurdity. Neither of the parties have contended in that direction. Neither of the parties to the contract, that is to say. Neither of the parties have said that the contract does not work, which are the considerations that have derived from the learning in the numerous cases which have been referred to before the court. And it is not my intention to repeat them, because I know that those cases are well known to this court, very well known to this court. But
Where do you most conveniently find the term in question? In the Respondent's case at paragraph 2.
My apologies, my lady. I didn't quite
Well, as we're considering a particular clause in a contract, it's also in the Statement of Facts and Issues at paragraph 6. Is that right?
Yes, my lady.
I mean, the actual agreement starts obviously at 103, and clause 3.1 is at 106, isn't it, Ms. Henry?
That is correct.
Yes.
You prefer the primary sources rather than
I do,
the secondary sources, yes.
The clause in under consideration is the purchaser agrees to assume, pay, perform, and discharge all of the debts and liabilities of the bank on the final balance sheet and in the supporting books and documents of the bank, including all subsisting contracts related to or held in connection with the said liabilities, whether secured or not, in respect of the said business subsisting at the transfer date, except the liabilities expressly excluded in subclause 2. And our contention is that the relevant phrases or clauses in that paragraph are that the debts and liabilities of the bank on the final balance sheet, which are except those that are excluded in the subclause 2.
But, I mean, the liabilities also in the supporting books and documents of the bank.
That's correct.
And I think you just pointed us to some evidence that the bank was well aware of the claim.
That is the evidence that was before the court.
So might it not be said, if it qualifies as a liability, even though not recorded in a judgment yet, that it is a liability in the supporting books and documents of the bank?
There's no evidence in relation to that specific point. I accept what was put in evidence is there, and I can do, I can't but accept that. But it would appear to me that as of the date of the contract, notwithstanding that Mr. Byron had in fact been terminated some 2 years prior, or a year and a bit prior, the claim was not being accepted by the bank.
But the expression is not supporting books and accounting records of the bank, it's supporting books and documents, which is a completely generic phrase that could include correspondence or emails or anything else.
Or a contract of employment,
I mean,
if in writing.
yeah, and presumably Bank of Antigua knew that they had employed Mr. Byron.
Well, there was some issue in relation to whether he was employed at the time of his termination by the bank itself or by Mr. Stanford. That was an issue which, albeit did not come out at a trial per se, because Bank of Antigua did not participate in the trial. It seems to have been an issue that was taken by Bank of Antigua, that he was not in fact an employee of Bank of Antigua Limited, but he was Mr. Stanford's person in the bank or employee in the bank, and that was addressed by the court. But not having participated in the trial, and there being sufficient basis on which the court could make a determination that he was in fact employed by Bank of Antigua, that matter resolved itself in that way at the end of the day. But I have to accept that the Bank of Antigua knew of the claim that was being canvassed by Mr. Byron. I would urge on the court that it did not accept that that claim was well-founded, as at the date of the contract, did not include it as part of the items that were sold, and based on the evidence that Mr. McDavid led or gave, had made provision itself for settling up any debt that might have been found to be due to Mr. Byron.
The Bank of Antigua had.
The Bank of Antigua.
And is that in the evidence?
Yes, it is in evidence. It is in the evidence of Mr. McDavid. I referred to it a moment ago in the cross-examination.
No, I've got that reference, thank you.
So we say that inasmuch as it is not the role of the court to rewrite terms for parties to a contract, regardless of how unwise, ill-advised, etc., the contract as framed may appear to a court to be, we say that in those circumstances, the implying of a term in the language as canvassed by the court, or as made by the court, so that the clause now reads, the purchaser agrees to pay, perform, and discharge all of the debts and liabilities of the bank on the final balance sheet and in the supporting books and documents of the bank, or that properly ought to be reflected in the aforesaid documents, is in fact a rewriting of the contract for the parties. And does not meet, and I would just refer for convenience to the case of Arnold versus Britain, which is at tab 9. And I only refer to it because it very conveniently in point form sets out 7 factors which I believe distillation of the principles that one would apply if,
Page reference, please.
my apologies, my lady, page 283 of the bundle of authorities.
Yes.
And as I said, it's at tab 9. 283, starting from paragraph 17, and continuing over to 284.
This is another famous Neuberger list. He is famous for his lists, and this is one of the most famous of them.
Well, you know, lists can be convenient.
They can indeed. Yes. Yes, it wasn't a criticism, it was just an observation.
But I think that those are the considerations all in one place, if I can put it that way. That the court would
And which of them would you most want to?
well, perhaps I might say all, but my eyes are drawn to paragraph 19. 19 and actually 20. The third point which I should mention is that commercial common sense is not to be invoked retrospectively. The mere fact that a contractual arrangement, if interpreted according to its natural language, has worked out badly or even disastrously for one of the parties. And again, I have to emphasize that we're not here dealing with two parties to a contract. It's not a reason for departing from the natural language. Commercial common sense is only relevant to the extent of how matters would or could have been perceived by the parties or by reasonable people in the position of the parties as at the date that the contract was made. Fourthly, while commercial common sense is a very important factor to take into account while interpreting a contract, a court should be very slow to reject the natural meaning of a provision as correct, simply because it appears to be an imprudent term for one of the parties to have agreed, even ignoring the benefit of wisdom of hindsight. The purpose of interpretation is to identify what the parties have agreed, not what the court thinks they should have agreed. Experience shows that it is by no means unknown for people to enter into arrangements which are ill-advised, even ignoring the benefit of wisdom of hindsight. And it is not the function of the court, when interpreting an agreement, to relieve a party from the consequences of its imprudence or poor advice. When interpreting a contract, a judge should avoid rewriting it in an attempt to assist an unwise party or to penalize an astute party. Perhaps the fifth point is also very helpful or useful for consideration by this court. And I move to the third sentence. Given that a contract is a bilateral or cyanomatic arrangement involving both parties, it cannot be right when interpreting a contractual provision to take into account a fact or circumstance known only to one of the parties. As I said, all seven, I think, are the principles that the court look at.
Well, both parties to this contract knew about Mr. Byron's claim, didn't they? You've just shown us the evidence from Mr. McDavid, who's for the purchasing bank, that they knew about the claim. And obviously the Bank of Antigua knew about the fact that they'd got this employee who'd been dismissed, or at least person claiming to be an employee who's been dismissed. So both parties to the contract knew about this fact.
Mr. McDavid, yes, he was an employee of, originally an employee of Bank of Antigua.
Yeah, but he gave evidence on behalf of your
And then he gave
client.
evidence because he was then an employee of ICA.
Yeah.
I accept that. I accept that. I accept that point.
Mind you, of course, it's completely extraneous to anything that Mr. Byron knew about because he's not a party to the contract. It's completely extraneous to anything that Mr. Byron knew about because he's not a party to the contract.
He's not a party to the contract.
He's the beneficiary of the assumed assignment of the liability, presumably.
I didn't quite get that.
Well, the reason that we're talking about the contract is that we're trying to identify the debts and liabilities that were assigned by virtue of that contract, and which, presumably, therefore, a third party, such as Mr. Byron, has got the right to take advantage of that
Yes.
assignment. That's
Yes.
what we're arguing about,
That
what
is
was
what-
and was not assigned.
That is what we're arguing about, and we are saying it was not assigned, and it patently was not assigned, because had it been assigned under the contract, then we say it would not have been necessary to imply a term, to say that even those that were not part of the books and records and documents would in fact be pulled into the net. Had it been understood, had the language of the contract been understood to mean that, then there would be no necessity for implication. But patently, the parties did not include Mr. Byron in their contract.
Could I ask, was a closing statement served under Clause 12 of the transfer agreement?
I'm afraid that I'm not in a position to.
The reason that I ask is that in Clause 12
Yes.
of the transfer agreement, a closing statement was to be drawn up of all the assets and liabilities of the bank as shown on the bank's final balance sheet and
Yes.
books and records as of the transfer date. That seems to be tracking the language in Clause 3. And in Clause 12.3 it says, when the closing statement has been determined, the amount shown in the closing statement shall be final and binding for the purposes of this agreement.
Yes, I actually saw that. Two things I would like to say here. That did not come up in the evidence at all. In point of fact, when you look at the case as tried before the industrial court, the contention of the employee, who is now your respondent, was that that the appellant, ECAB, was a successor employer within the meaning of the Antigua and Barbuda Labor Code. So that the case as tried in the industrial court did not delve evidentially into the purchase and assumption agreement. So a matter such as that, the question as to whether or not the closing statement was in fact concluded as contemplated under the agreement, did not come out in the evidence. That was not addressed. The issue did not arise in the industrial court. And in point of fact, even when the matter was going to the Court of Appeal, the employee's contention was still that that the bank was a successor employer, ECAB.
And am I right in thinking, is that under Section 45 of the Labour Code? Is that the provision that deals with statutory designation of successor employers?
I believe...
Look, don't worry. If
It's Chapter 45
Yes.
on 208 in the authorities bundle, isn't it?
Yes. The successor employer is dealt with under C44. So that if somebody becomes...
I thought it was 45, but you may be right.
No, it's C44. Severance pay is not payable if the employee's employment is terminated by an employer who has gone out of business, but without any break in service. He's offered the same employment by a successor employer. So that establishes what a successor employer is. And the liability to pay severance dating back to the date of employment by the original or the predecessor employer is what is dealt with in paragraph C45.
You're right to say that when Mr. Byron appealed to the Court of Appeal, and we've got his notice of appeal at 16,
Yes.
he was still saying that your bank was a successor employer. So the question is, when did he shift his ground?
While he was arguing in the Court of Appeal.
Orally,
Yes.
before the Court of Appeal?
Yes.
Very well.
In point of fact, that is specifically referencing the judgment of the Court of Appeal. Which is at the beginning of the record. Starts at page 1. The court does make the point that there was a concession by my learned friend that the bank, the respondent here, the employee, was not in fact, or the ECAB was not the successor employer.
Yes.
Now, if we look at the judgment of the industrial court, you'll see in the last paragraph of that judgment. The judgment of the industrial court starts at page 22. And if you look at page 6. There was a third issue that was considered. If no redundancy existed, what is the measure of damages which is due to him? Which defendant is responsible for the payment of damages to the employee? And you will remember that this is a judgment delivered on the 30th of March 2012. Judgment had already been entered against Bank of Antigua in December of 2011. I agree with counsel for the employee that Mr. Byron was dismissed for redundancy. That apart, they have failed to examine in any material nature, in particular, the nature of the redundancy in this case. I have not had the benefit of any cases cited by counsel for the employee to assist this court to arrive at a determination of the issues to be tried. In the circumstances of this case, I am unpersuaded by their arguments that any judgment which is awarded for the employee should be paid by ECAB. So the matter really was not advanced.
But the Court of Appeal didn't seem to be troubled by that, did they?
No, they were not. I believe that the Court of Appeal felt that, and I haven't come to it yet, Section 10.3 of the Industrial Court Act was sufficiently wide to allow the order to be made, the just and equitable clause, if I can put it that way. So that while the Court of Appeal did say that it felt that the term could be implied, I think that when you read the judgment in its entirety, the sense that one gets from the Court of Appeal judgment is that it felt that in the circumstances of the case, in all good conscience, ECAB should pay this judgment. And I think that that really is the thrust of that judgment.
You don't dispute that, the Section 10 jurisdiction?
Well, you see, I think I'm not going I think that if one does not take account of the fact that there was clear evidence, uncontroverted evidence, that all of the assets were not in fact transferred to ECAB, because I think that was misapprehension number one, if I could put it that way. There were two pieces of property located in High Street, or in St. John's in Antigua, which is the capital of Antigua and Barbuda. There were two properties, and that is in Schedule 5 to the Purchase and Assumption Agreement, the description of those parcels.
Mm-hmm.
But I believe that somehow or the other that got lost in the shuffle, because the general thrust of the case was everything had been transferred to ACAB. Bank of Antigua had nothing.
But on this appeal, your only point is that the liability is not covered by clause 3.1. You're not taking a point about section 10. We're not concerned with the Court of Appeal's views on section 10.
Well, we are concerned with their view because, as I said, even though they seem to have wrapped it up into one issue, in that they seem to have suggested that because it would not be, because of section 10.3,
yes,
they could make that implication.
Right, but it's still a question of implied term into clause 3. We're not interpreting section 10. There's no issue about that. There's no separate issue.
I accept that 10.3 does give the court wide powers. I accept that. What I say is that it does not give the court wide powers in these circumstances.
To imply a term.
To imply the term and to say, to rely on the power to make a determination based on equity and good conscience, if I can put it in those terms.
Ms. Henry, do you think that when we wrestle with whether the Court of Appeal relied on section 10.3 in concluding the appeal, we ought to look at paragraphs 20 and 21 of its judgment,
Yes.
which we find on page 11 of the record? Court must give effect to the ethos and philosophical approach mandated by the subsection. 21, adopting that approach, it was open to the industrial court to make an award or order in accordance with the guidance given.
Yes, but that was that. Yes, exactly. And it seems that that is what drove the decision to imply the term. Because when we look at the judgment, sorry, I'm not accustomed to this. To be very honest.
You're brave to be using it at all. I'm afraid I can't, and so I'm using paper, and I wish that you were.
So do I, Millard. And
Well, you're welcome
with
to
the
use
benefit of
paper.
hindsight,
Yes.
I won't do this again.
You're welcome to use paper as long as the paper that you use notes the electronic page references.
Thank you
That's
very
all
much.
we need
Thank
to know.
you very much.
But worry not,
Thank
and
you
wrestle
very
on. You'll get the hang of it.
Well,
Next time you'll be doing it brilliantly.
I'm not sure that I will make the effort the next time, but paragraph 15 of the judgment, which is at page 9. That is where the court refers to the Attorney General of Belize and Belize Telecom, and that line of cases would apply, would come into sharp focus. And then he goes on to say, I am of the view that there is much merit in the implied term contended for by the appellant in clause 3.1. The respondent's arguments against implying a term are not well founded. The agreement did not exist in a vacuum, and it does not contradict. I'm just moving quickly through that paragraph.
But the Court of Appeal is applying the standard tests for implying a term. There's nothing here about section 10.3 gives any added authority or power to the court. The only question, therefore, with which we are concerned is the interpretation of clause 3.
I agree that in that paragraph, the reference is to the principles that would govern the implying of a term. I accept that.
But at the same time, independently, the court says that justice, fairness, good conscience, and the substantial merits of the case would have resulted in the respondent being jointly and severally liable. That's paragraph 21.
Now,
So it sounds as if they've got two.
well, except that if they
Strings to their
imply the
boat.
term,
Then they don't need 10.3.
Then the debt goes wholesale.
Yes.
The debt goes wholesale to ECAB.
Yeah.
Because it is now one of the items that was sold.
Yes, yes. Quite right. There's a distinction between holding them jointly and severally liable and holding and implying the term or construing paragraph 3 to include this liability.
So that they clearly felt emboldened or authorized or, yes, emboldened to rely on 10.3.
They produce different results. That's the point you're making. Under 10.3, they made the two banks jointly and severally liable.
Under 10.3, they said they were jointly and severally liable, but they did not take into account under 10.3 all of the factors which I believe that they should have taken into account. Because 10.3 says that the court can make such order or award in relation to a dispute as it considers fair and just, having regard to the interests of the persons involved. And one of those persons, of course, is ECAB. Obviously, Mr. Byron was involved as well, or concerned in the matter.
Could you please, for my benefit, explain what in your submission is the scope of this power under Section 10?
Well, I think that actually has been dealt with by this court in the past. In the case of Cable and Wireless, is at tab 11 of the bundle, page 344. A case with which I have some familiarity.
And I ought to, but I don't think I do. Forgive me, Miss Henry. Which paragraph would you
15.
like? 15, thank you.
Which is at page 350. The Court of Appeal, the Industrial Court, sixth line, applied the right principles, namely those required by Section 10.3 of the Industrial Court Act. The court is to make an award which is fair and just, having regard to the interests of the employer, the employee, and the substantial merits of the case, having regard to the principles and practices of good industrial relations, and in particular the code. There's no real similarity in the facts of that case with this one, but that is the principle that has been, if I can put it this way, distilled from that case.
So the facts of that case were that this was an argument there about the quantum of the severance pay.
That's correct.
Is that right?
That's correct.
Very well.
And in that case, the court did not agree with the argument advanced for Cable and Wireless that the burden was on the employees to show that Cable and Wireless had been unfair. It was open to the industrial court, as it did in that case, to make another arrangement for the payment of severance where none had been agreed between the parties in their collective agreement. But I think that what the court, the Privy Council said in that case, and we accept that is a principle, is that the industrial court can look widely at the situation before it to make a determination as to whether or not, as to what is fair.
In terms of quantum or liability?
In terms of the award, whether it is an award fixed in liability or it is an award fixed in quantum. It has a very wide breadth, is the essence of the judgment. But it still has to act taking into account the interests of the persons who are involved. And we say that the interest, that when you look at 10.3, the interests of the bank, ECAB, who has not purchased this asset, this liability.
Well, let's just...
And now, some year and a half, 2 years later, finds itself saddled with a debt for which provision plainly has been made according to the evidence before the court.
Provision by whom?
McDavid.
Well, he's simply saying that the Bank of Antigua knew about the liability. He didn't say they made a provision.
They have assets that could cover it. That is fair enough.
That's where
That is fair enough. That is fair enough.
There's no provision.
What he has said is that there were assets that the Bank of Antigua would take care of the debt or the liability. That is what his evidence is, and the purchase and assumption agreement shows that there were, in fact, 2 pieces of real property in St. John's in Antigua.
But the controlling document is Clause 3, and if the Clause 3 includes the liability to the respondent, then were we concerned with Section 10.3 at all, having regard to cable and wireless?
That is where the court went.
That's where the Court of Appeal went, but there's no point of appeal, no issue on the appeal here. There's only one issue, the construction of Clause 3. Am I wrong about that?
I thought that in paragraph 23 of his case on 195, Dr. Dorset was relying on Section 10.3, Ms.
Yes,
Henry.
he is. He is relying on 10.3.
We've obviously got to look at it.
He is relying on 10.3 because he is saying that it is fair to the party involved, and that is a consideration that the court must take into account.
You are conceding that Section 10.3 is wide. Of course it is. But when we look at the Labour Code and remind ourselves that rather obviously it's for the employer to pay severance pay, are you saying that Section 10.3 is so wide that the industrial court could say, for reasons A, B, and C, we think that this severance pay shouldn't be paid by the employer, but should be paid by X?
I don't think it has that power.
No.
I don't think it can go that far. It would be constrained.
It does, to some extent, depend on what is meant by the interests of the persons immediately concerned.
Yes.
In 10.3a.
Yes. Which is...
And in fact, is ECAB immediately concerned? Because it was never the employer.
No, that is correct.
So is it, for the purposes of any industrial dispute or dispute between employer and employee, a person immediately concerned?
Well, it is concerned insofar as the order
Well, it's there before the court, but that doesn't necessarily mean...
That's probably as far as it goes, yes. Yes, my lady.
Do we get any assistance from the Berridge case and the decision of the board in that case behind tab 6? What I've got in mind in particular is paragraphs 12 through to 14 of the judgment.
Could you give us a page reference?
I beg your pardon, 242 and 243.
Thank you.
Yes, my lord. And in point of fact, I think I referenced that in the submissions that I had filed to the court. Because, in fact, the what it says in paragraph 14, I think, is the section to, or the paragraph to which you have referred. It seems to their lordships that the binding effect of a statutory statement of reasons for dismissal is an integral part of the principles and practices of the code, etc. And the industrial court could not have been intended to be able to jettison Section 10 simply on the grounds that a less draconian rule would be fairer.
You're suggesting that that suggests that they can't just do what they fancy. Lord Kitchen, are you suggesting are you suggesting
Yes.
by drawing attention to this that Section 10 doesn't mean that they can't just do what they fancy?
Indeed. I beg your pardon. I thought the question was directed.
No. I was trying to understand the
Yes.
point you were making by raising the case.
Yes, that was the heart of the reason for my drawing your attention to this. To what extent does it assist us to understand the limits of the jurisdiction conferred by that particular section?
Well, Section 10 would not avail the industrial court where there are clear principles that delimit the circumstances that appear in the facts before the court. I'll put it in that way. So that it is not every time that the court feels that somebody has been hard done by that it draws on 10.3 and says, well, you know.
But the logic here is this, isn't it? You cannot just bring anyone off the street and say, you're going to be liable to pay this applicant's severance pay. But here, the ECAB was a person who, on the court's analysis, had agreed to pay this liability anyway, and therefore there was jurisdiction under 10.3.
But we say that that analysis was flawed.
Because of the interpretation point.
Yes.
Yes, that's right. So the real issue is the interpretation point.
Well, we're going to look at both of them anyway, so it's, you know, we needn't argue about what's before us. We're interested in everything.
I don't know if there's any, if I can give the court any further assistance.
You started with the point that your client was only before the industrial court because of the allegation that they were a successor employer.
That's correct.
Which they clearly weren't.
They clearly were not.
Yeah. And if it hadn't been for that, there wouldn't have been any basis for the industrial court including them in an award, which it didn't.
That is correct.
And you
So we
say that you move up to the Court of Appeal and there's still no basis for including them, at least for the purposes of Section 10.
I'm sorry.
But there are two separate
sorry.
parts. There were two separate parts of the Court of Appeal's reasoning.
Yes.
That's what we were identifying earlier.
Yes.
There was the implied term point.
There's implied term.
And or construction point, depending on how you want to look at it. And there was what may or may not have been a make-weight, which was Section 10.
Well, but when you look at the final result,
Yeah.
it would seem that 10.3 was the rule of the day in the sense that it was a joint and several liability.
Exactly. Yeah.
Whereas plainly, if the construction point had gone the way that they suggested it did, then Bank of Antigua would have been in the clear, so to speak.
Are you saying that the order made by the Court of Appeal provided for joint and several liability?
That is what it's expressly stated.
Do we have it?
Yes, we do. Well, you have the outcome of the case.
Yes,
14.
page 14, yes.
The appellant
32.
Yes, takes it.
Paragraph 32.
Yep.
Yeah.
It is declared that. Yes, we've got that.
joint and severally liable.
Very well.
Thank you.
Thank you.
So that would suggest that, in fact, Clause 10.3 was the primary ground for the decision.
It could only be that. It could only be that, because had it been that they had interpreted that the contract included Mr. Byron's debt, if I can put it that way, then that would have gone over to ECAB, wholly and solely.
That would prejudice the employee, potentially, if there was an asset in Bank of Antigua.
But there were assets in Bank of Antigua,
Yes.
which she could have gone after, which she clearly decided not to.
But the Bank of Antigua and ECAB could not together remove an employee's right.
Oh.
Because there was no consent by the employee. So he retained his rights against Bank of Antigua.
Thank you very much indeed, Ms. Henry. Thank you. Dr. Dorset.
If it please you, my lady, the central issue before the Court of Appeal and this court, I think, is captured by what we see at paragraph 11 of the judgment of the Court of Appeal. This is found at page 7 of the record, page 7 of the record, paragraph 11. The central issue in this appeal is whether the respondent being ECAB, is liable for the payment of the severance due to the appellant on his being made redundant by the Bank of Antigua Limited. The thrust of the appellant's argument, as articulated in the oral argument is to the effect of the agreement. And the appellant's basic contention is that clause 3 supports the position that the respondent is liable. Then moving on to paragraph 16 of the judgment, the Court of Appeal judgment, the Court of Appeal, after assessing the arguments both by Mr. Byron and on behalf of ECAB, and with particular reference to this board's judgment, in the Belize case, held with Mr. Byron at paragraph 16, where the Court of Appeal held that there is much merit in the implied term contended for by the appellant in clause 3 of the agreement. So I would respectfully submit that the thrust of their decision, having identified what the central issue was the construction/implication issue, what I call the contractual issue. The issue of the bank ECAB being jointly and several is just a flow on from that, to the extent that it is only after dealing with the central issue, concluding at paragraph 16, then the court moves on to section 10.3.
So are you saying that it was a necessary part of the Court of Appeal's reasoning to find the implied term? It was only if they did that they could then have recourse to their powers under clause 10.3?
No, they could always have recourse to 10.3, but in this particular case, I think they have in regard to one, the jurisdiction under 10.3, and in particular how the industrial court seemed not to have properly used its jurisdiction under 10.3, thought it necessary to address it. And it addressed it and says that, for example, at paragraph 20, the Court of Appeal makes the complaint that the industrial court was required to make a just and fair award, and in the view of the Court of Appeal, it simply did not. So that is in the context in which 10.3 arose. But again, the central issue for the Court of Appeal was what I call the contractual issue. But having regard to section 10.3, which could not be ignored in any event, and in particular having regard to how the failing, if I may say, of the industrial court in dealing with the matter, it felt it necessary to address it, and it did so, and it concluded that having regard to 10.3, that it would be just, fair, and equitable having regard to all of the circumstances and to the parties concerned.
The failing of the industrial court, that's a bit unfair, Dr. Dorset. The argument before the industrial court was successor-employer.
Well, I am just, my lord, perhaps I was a little strong in the language, but the point from the Court of Appeal is that as it states in paragraph 20, that the Court of Appeal was required to make a just and fair award. And if I may respectfully submit, the reason why the court says that is suggestive that the industrial court did not.
Dr. Dorset, I'm having a little difficulty following your submission. Are you submitting that were this board to find against you in relation to the implied term issue, your client could nevertheless prevail on section 10.3?
Yes.
I see.
Yes, that I think is the nub of our position.
Right.
And we respectfully submit. I think we have made out our arguments fairly clearly. I don't think it is necessary to go hammer and tongue point by point. But as a matter of construction, of simple construction, the ECAB is liable. Look at the contract itself, which begins at page 103. And the purchase and assumption agreement, the relevant clause found at page 106, at the bottom of page 106 of the record. The purchaser agrees to assume, pay, perform, and discharge all the debts and liabilities of the bank on the final balance sheet and in the supporting books and documents, whether secured or not in respect of the said business, except the liabilities expressly excluded by subclause 2. Well, look at subclause 2. The liability of Mr. Byron is not excluded. A number of things are excluded under 1, 2, 3, 4, 5 different heads. But as a matter of construction and plain reading, the liability of Mr. Byron does not fall into one of those. So,
does it not fall? It may or may. I'm not making any point other than to ask you: might it not be thought to fall within 2B, pending litigation?
No, with respect, and we have addressed it in our case. It wasn't pending litigation because at the time of this agreement, on the 12th of October 2000, there was no pending.
There was no pending litigation. Yes.
Yes. So, I think we have addressed that, and I hope I've answered.
And you also addressed contingent liabilities as well, didn't you?
Yes, madam.
So if the bank had these splendid premises in St. John's Street, St. John's, Antigua, and it had a refurbishment contract with contractors, and so much work had to be done, and then there was a certificate, and then there was payment. In the balance sheet on the transfer date, what would you expect to find?
Well, we would expect that, if not on the balance sheet, somewhere in the notes in the balance sheet, that reference would be made to these circumstances. And if I may say so, when one reads these balance sheets, there's always a note that says that the accompanying notes are to be read in conjunction and seen as part of the thing.
True, but the amount may not have been material in relation to this bank. It may have had so many deposits and so on. But supposing that there was an amount due and payable at the transfer date, you would expect to find that under liabilities, under current liabilities.
Yes, we would expect that. And what we say, perhaps, and I mean, we have advanced this, perhaps through mistake, oversight, or otherwise, they fail to put it in their records or on the balance sheet. But that they're what I call sloppiness or inadvertence.
There was no provision for audit of this document, was there? There was simply a balance sheet. There was no provision for any professional opinion to be obtained upon it.
I wouldn't have.
The agreement doesn't seem to provide for it. So there could have been exaggeration, there could have been understatement, anything. So it's not unusual to find that, not unsurprising to find, that the drafter went on to tell the reader to look at the supporting books and documents.
Yes.
Now, if we go back to the refurbishment contract, there is only one amount due and payable, but let's suppose it's a long-term contract because it's a complicated refurbishment, and there's going to be an amount payable in, say, 6 months when they've done something else, and 8 months when they've done something else. Those further sums, you wouldn't expect those to be shown as current liabilities, would you?
No, but certainly I think a responsible preparer of those kind of documents would make reference that these are things looming on the horizon.
Well, there's no, obviously a balance sheet is simply a statement of liabilities and assets. It doesn't have prospective liabilities of that kind, or even contingent liabilities necessarily. They might be noted, but you would expect to find them in the supporting books and documents.
Yes.
But you would expect to find the contract, and indeed the drafter has gone on to say, including all subsisting contracts. So you're going to have to do a full survey of the bank's financial position in order to know what liabilities are being assumed.
Yes.
We're not just pinned to the liabilities. But don't the words supporting books and documents also tell us that we've got to look for things like the payments in the future on the refurbishment contract, things that haven't yet accrued as current liabilities?
Yes, all of those matters ought to be properly looked at and considered, yes.
And would then become debts and liabilities of the bank to which Clause 3.1 applies. So you would be looking at not just the statement of current assets and not the statement of assets and liabilities, but also things that might turn out to produce liabilities, because the whole idea was that the purchaser would take over everything except the excluded items.
Yes, and
that's the way it's drafted.
Right, and the supporting books and documents would include, I think, employment records, and having a proper look at the employment records. What is the proper state,
yes,
or any liability, if any, attaches to persons who are mentioned or referenced in the employment records?
So it's a full examination. And the way the clause works is everything goes over to the purchaser unless it's specifically excluded.
Yes.
And it's not contended it's excluded.
Well, I don't think it can be properly contended. So,
Dr. Dorset, are you making a new point then? Are you making the point that the liability to your client would have been recorded in the supporting books and documents? Because I thought I thought that it was common ground that there was no reference in the supporting books and documents.
yeah, but what I'm saying, the supporting books and documents would include employment records, and employment records should properly inform the reader of those records what, if any, liabilities would attach to those named employees.
Was there any evidence about this? I mean, was this part of your case at any stage, either before the judge or the first tier, or on appeal to the Court of Appeal?
It featured minimally at the industrial court, but it featured much more prominently at the Court of Appeal.
But Mr. McDavid accepted that the Bank of Antigua knew about this claim, or the prospect.
Well, yes, because in fact there was correspondence. If you look at the record, there is correspondence, in particular the correspondence from at page 95, beginning of 95 and 98. It is mostly one-way correspondence, but it is suggestive that the bank had been engaged in dealing with the matter. And if you look in particular at the record at page 101, which is in the nature of an email from Watt and Associates, from Sir Gerald Watt, to then counsel for the bank, Bank of Antigua. It is stated there that you have agreed the sum of $612,000.
So it's within supporting documents, within of the bank.
Yes, and if you note, this particular email is at July 2010.
Yes.
July 2010. The agreement is October 2010. Mm. So this forms part of the whole.
Dr. Dorset, I thought you were coming here to defend the implication of a term.
Yes, but...
are you now saying that, in fact, there was an express term?
No, what I'm saying...
assigning to amalgamated liability for your client's severance pay?
No, I'm not making a new point. What I'm saying is that before one gets into implication, one must do interpretation or construction of what is there. I mean, that is what the authorities say. Before we get to any issue of implication, we must first do an interpretation of the express term. And what I'm saying, as a matter of interpretation, the liability falls on ECAB. And even if we go beyond that to do implication, the liability also falls on ECAB. So implication arises, but you don't just jump to it. You must first interpret, and then, as need be, move on to implication. And I think I would have made that point in our written piece. I'm not here to make a new point or a new argument. I'm trying to make an argument consistent with what my written case is and consistent with what the case that was advanced in the Court of Appeal.
And which paragraph in your written case do you have in mind?
Paragraph 9 of my written case, page 190 of the record, paragraph 9.
Thank you.
The express terms of a contract must be interpreted before one can consider any question of implication, and that rises from the Mark and Spencer case, another one of those Lord Neuenberger judgment with his list. In fact, paragraph 28 of that particular judgment.
Is it paragraph 14 too? As a matter of ordinary, I beg your pardon, this is on page 192. As a matter of ordinary construction, the severance is deemed to be a debt or liability of BoA, which the appellant had agreed to assume, pay, perform and discharge?
Yes. I've also made that point at paragraph 14. That is correct.
The gist of your argument in these paragraphs is that clause 3.2 does not exclude your client's severance pay. That point is only relevant if clause 3.1 does include it.
Yes, and what we say is that one looks at the documents of the bank. The documents of the bank would or ought to include employee records. It would also include, by extension, the correspondence that I have drawn the board's attention at page 101 of the record, correspondence of July 7th, 2010.
Statement of facts and issues, paragraph 16, appeared to identify a single issue, which was the issue of implication. So I'm just a little bit confused as to the point that you now seem to be making, which isn't, as I understand it, purely a point of implication. You're saying, leaving aside implication, on proper construction of clause 3.1, the liability was included on the express words in 3.1.
Yes. Well, this issue clearly can only be properly addressed if the construction issue is somehow dealt with. As I said, you just can't go full force into consideration of this without addressing the interpretation issue. I mean, this flows or has its foundation on having done some kind of construction exercise. And what we say, having done the construction exercise, it is in favor of our position. And even if one goes on or needs to go on to the implication for the reasons that we have addressed in particular at paragraph 15 of our written case, page 192 and 193 of the record, implication would be proper. And we use the example, if there is a mistake or some error on the part of the records, surely it could not make sense that those realities be ignored in dealing or giving effect to the contract. And I give an example. I hope I'm not being too brutal or too brazen by the example I have given in paragraph 17 of our written case, page 193. For clarity, the fourth line down, beginning there, if the balance sheet had mistakenly stated that a party A was owed the sum of $1,000, when in reality the sum of $100 $100,000 was owed, surely the appellant, that is ECAB, could not reasonably say to party A that it must be satisfied with a payment of $1,000, must be accepted in full and final complete settlement of, and that's a typography of what is in reality a $100,000 debt.
Nor would it make the Bank of Antigua solvent again, because the rest of the liability would be left with it.
Yes.
And so the parties wouldn't have produced the overall commercial result. And likewise, as we discussed a moment ago, there's no audit. So you would expect the purchaser to want to look at the books and records.
I mean, just on your example there, do you want to say something about Clause 12, and in particular Clause 12.3 of the agreement? Because that seemed to be a provision aimed at the defining precisely the assets and liabilities in the closing statement. And Clause 12.3 says that the closing statement shall then be final and binding.
Yes, but that does not mean that an implication where necessary in this agreement, that does not, what I respectfully submit, preclude an implication, or a proper implication. And we accept the agreement for what it is.
Well, I mean, sorry, just on that, might it not be said that it has something of a tendency against the implication part of your argument, in that it seems to show the parties very concerned to identify with precision what assets and liabilities are to transfer across, to have that set out in a closing statement, and for that to be a final and binding document as between them?
Yes, but here, what I would respectfully submit, we are not seeking to imply anything into the closing statement. We're seeking to imply something into the agreement itself, so that the agreement is binding, and the agreement would include any implied terms. And I would also, your Lordship has drawn attention to paragraph 15. I would also, if I may, draw attention of the board to your Lordship has drawn attention to clause 12, clause 12.3. If I may draw the board's attention to page 109 of the record. 109 of the record, clause 5, where it is stated there that the vendor will be responsible up to the transfer date, and the purchaser will be responsible thereafter for all outgoings, running expenses, and any other liabilities incurred with respect to the business of the bank. And we would respectfully submit that the liability created upon the employee, Mr. Byron, being made redundant, is a liability that would be captured by this agreement.
When was that liability incurred?
Upon termination, back on the 12th...
Back in 2009?
2009.
Yeah.
In fact, almost 10 years ago, 20th of February 2009.
Well, the transfer date is surely a date in October 2010. I think it's the 18th, isn't it?
Thereabouts, I would not...
Clause 15, let's just check.
Yes, it is.
Yeah, 18th...
18th of October. So reading 5 again, the vendor will be responsible up to the transfer date, 18 October 2010. The purchaser will be responsible for thereafter for all liabilities incurred with respect to the business of the bank. So vendor, that's the central bank, and in effect the Bank of Antigua being responsible for liabilities incurred prior to 18 October. And we know, and you've conceded, we know from the Labour Code that severance pay is payable immediately upon redundancy.
Yes, no.
So that's against you, isn't it?
Well, I can see what my Lordship is saying. The general point I am seeking to make here is that when one looks at the agreement in whole, what it clearly shows is a purchase and assumption agreement. Because one of the things to construe an agreement, and in that exercise, if one needs to put the implication, to understand what is the nature of the agreement And it is clear throughout that the nature of the agreement is, one, purchase assets, and secondly, assume liabilities. And that is what, throughout the agreement, that theme is repeated time and time again with respect to various matters.
Did your client have a written contract of employment with the Bank of Antigua?
I suspect he did. I would be astonished if he did not.
You'd be astonished if he didn't. Is it
Yes.
normal practice?
Yes.
Well, if we don't know, we shouldn't speculate, but if it's
Yes,
normal practice...
I think my learned friend accepts that there was.
yeah.
Yes. So that is what I would respectfully submit in terms of the substance of our case, both as a matter of construction and as a matter of implication, that the term that we have contended for should be implied, and in any event, having regard to the circumstances that the Court of Appeal, in using or invoking its jurisdiction under Section 10.3 was right. And what I would say is this: if the Court of Appeal was right on Section 10.3, it really doesn't matter whether it was right or wrong on the interpretation implication issue. I mean, at the end of the day, if it was right on Section 10.3, and we respectfully submit that it was, when one looks at Section 10.3, reading what it says, and Section 10.3 is to be found at tab 3 of the bundle, page beginning at tab 3 begins at page 209 and continues at page 210. Notwithstanding anything in this act or in any other rule of law to the contrary, and we respect, that means rule relating to interpretation of contracts and implication of terms therein.
There must be some limit to this, mustn't there? Because, to take my previous example, the court couldn't select somebody off the street and say, well, actually, this is a good claim, but we can't find anybody liable, you'll be liable.
Yeah, well, I accept that, my lady. But what I'm saying is that unless this court finds that in the exercise of its 10.3 discretion, that the Court of Appeal was plainly wrong, just out and out wrong. It was what I call an outrageous decision by any measure. Then its application and its invocation of this jurisdiction ought to stand. And that is our case.
And usually when you have a discretion, if that's the right way to describe it, it's a ground of appeal that someone has taken into account an irrelevant or improper consideration when exercising that discretion. Yes. Well, might it not be said here that if the Court of Appeal was wrong to imply the term, they've plainly taken into account the implication of the term, and therefore the discretion, if that's the right way to describe it in Section 10.3, has been wrongly exercised by them, taking account of an improper or irrelevant consideration?
My Lord, I would not say that having taken into account an implication is an irrelevant consideration, because it used 10.3 not to find the bank ECAB liable, but to find it was jointly and severally liable. That was the only additional oomph that was given to the judgment by 10.3. Liability had been determined.
As well, that point is understood, but it's difficult to reconcile that point i.e. 10.3 was used to enlarge the liability to make it joint and several rather than solely the liability of ECAB, it's rather difficult to reconcile that with your previous submission that if the Court of Appeal was right on 10.3, it doesn't matter whether it was right on the interpretation or implication of the contract. That can't be so, can it?
Well, my lady,
they can't both be so.
We're looking at the outcome of the board's conclusion on this matter. If the court, this board, determines that the discretion on the section 10.3 ought not to be disturbed, what that means is that ECAB, the appellant, is jointly and severally liable. That is, and as far as the respondent is concerned, he is happy with that. If this board finds that ECAB is jointly and severally liable, we have no complaint. And so the fact that there may be an additional basis to find against ECAB, to me, it would just be, icing on the cake, if I may say so. And so unless I can assist further, that is our case.
It appears there are no further questions, Dr. Dorset. Thank you very much indeed. Ms. Henry, have you anything in reply?
Not really, my lady. I did note, however, when my learned friend was on his feet, that he did seem to be suggesting to the court that, in fact, the agreement on its plain reading would have included, if I can put it that way, the Byron debt. And I think that at that point, my Lord Wilson had asked whether this was a new point that was being advanced. But I think that the crux of the matter is that the respondent is contending that the necessity for implying arose from the fact that the Byron debt was not included in the contract. And therefore, my arguments in relation to that earlier advance would stand. Unless there's something else that the court wishes.
I'm just checking carefully to make sure. We've thrown a lot of questions at you both, so no doubt we have exhausted ourselves in that direction. We will now go away and exhaust ourselves in working out what the answer to the appeal is. And obviously, we will take time to consider what advice we will humbly tender to Her Majesty and let you know in the usual way in due course. Thank you both very much indeed for your attendance.